Yes, everyone, welcome. Come on in, get comfortable. We're going to have a wonderful discussion tonight. It's a lot of celebration and a lot of learning. Special welcome to all of the Legal Warriors Club members from the Free Now Foundation. Hello, Aria. I see you there, Toby and Lori, Ryan, Paula. You guys are wonderful to be here. We're going to have an exceptional conversation. You know, everyone's talking about this case all over the country, and you get the opportunity to hear directly from the lead litigant. That's the lawyer who shepherded this case, particularly toward the end, that made all the difference. And you're going to hear from at least one of the plaintiffs too, and so you can get some of the personal experience of what it's like to go through, first and foremost, a mandate. To be threatened to take an experimental injection just to keep your job, and then to fight back against it with if you were like me, I didn't know anything about mandates and what at the time, how do we even begin to fight against them? So these folks found their way and they were victorious in the end. Again, it's a celebration. We have so many losses sometimes, and then when we have those wins, we have to really take stock and celebrate and look at how is it that we came to win? What did it take, really? There's a lot of things that came together, and some people are pointing to the divine intervention because of, how against the odds this case was. And so we're going to hear from, as I said, the lead litigant in the case, Jessica Barsati, who's with us, and she's going to describe to you, of course, her personal experience of what it was like being in the forefront of this case, but some of the legalities. I don't know if many of you are, if you are or you aren't familiar with the ins and outs of discrimination in employment, when in particular religious discrimination. Every state has peculiar specific laws about how you're not allowed to discriminate if you're an employer against your employees based on their religion. And the federal law also has statutes, very strong. And until COVID, in fact, it's a very commonplace kind of litigation to see. But then in the COVID era, suddenly religious discrimination in employment for so many wasn't the thing that courts were allowing in the same way that they had for years in any other kind of way. But anyway, you're going to hear from Jessica about the legalities to get a good education, the basics of discrimination in employment. And then, as I said, we're going to hear from a couple of our plaintiffs and to get a personal side of what it was like to go through that heck and then come out at this wonderful time where we are now, having won this case. You're going to be, as you hear the story, you're going to be impressed by how it just wasn't going to happen. Like it's so against the odds, but it did happen. It's real. There are some loose ends. If we have time, we might get into that. We're going to be together for about an hour. We'll also take your questions. Shall we get started, Alex?
Okay, Jessica, I'm going to introduce you. Are you ready to come on? Jessica is a medical freedom attorney. This is not what her bio says, but it wasn't even a specialty before we got locked down. And Jessica is literally one of the pioneers of medical freedom law. And she has been with Facts, Law, Truth, and Justice since we got locked down. And she's on our board at Free Now Foundation. And she has been a litigator extraordinaire. She is the reason we've been so successful in so many of our cases during lockdowns. And we filed 10 cases while we were locked down. And Jessica was the litigator on most of those cases. She's a public interest graduate of UC San Francisco's Hastings College of Law, and she's been an attorney and civil litigator for 24 years in Oakland, California. She's a fourth generation Bay Area native with deep roots in San Francisco going back to the late 1800s, including family history with the Grateful Dead, although she didn't put that in here. Through her firm, the law offices of Jessica R. Barsati, she has represented clients in civil rights, constitutional rights, housing rights, police misconduct, real estate, business, and insurance litigation, including litigation involving faith organizations. Jessica is a highly successful litigator and trial attorney who has been lead counsel in 13 jury trials and multiple bench trials, vindicating her clients' rights again and again. And we've seen that at Free Now Foundation again and again. I can echo that. For the last 4 years, Jessica has been pursuing litigation against school districts and local boards of supervisors, along with attorney Nicole Pearson and Rita Barnett Rose through Facts, Law, Truth, and Justice, They represent parents, concerned citizens, and organizations such as Bobby Kennedy Jr.'s Children's Self-Defense California chapter, which was the original name of our organization until we rebranded as Free Now Foundation, PERC, and of course, Free Now Foundation. She most recently helped achieve the highest jury award for religious discrimination in the workplace related to the COVID vaccine in California through her trial consulting with the lead attorneys in that case. And that case is the one we're going to be talking about tonight. It's the BART employee case. Jessica is an experienced litigator and trial expert, continuing to offer legal services, and offers trial consulting and trial work through Barsotti Rose Consulting at barsottirose.com. And that's BARSOTTI Rose.com. And it's my pleasure to welcome Jessica, who's going to talk to us about Title VII. Thanks, Jessica.
Hey, everybody. Excuse me. Good to be here. Yeah, it's been a whirlwind since this trial, and I'm very excited to talk about how this happened here in California and in San Francisco in particular, which everyone considered the most difficult jury pool in the country on these issues. So, yeah, I don't know where you want to start, but
I think people feel like this is a religious exemptions case, and it is, but I think the confusion is that the decision really rested on Title VII. So I think people want to understand what that is and how that played into this case.
yeah, so this was a Title VII case, and Title VII is the Civil Rights Act of 1964. It's the thing that protects people from discrimination in everything from the employment to housing to other areas of life. And so in this case, there was, religious discrimination in the workplace because these plaintiffs had given notice to the employer that they had sincere religious beliefs that prevented them from following a policy. The policy was the mandatory vaccine. And so, once that happens under Title VII, what the employer has to do, they're required to accommodate the employee. And the only reason they can fail to do that is if they have what's called undue hardship. And so if they can show that there's undue hardship to accommodate the employee in any way, then they can, terminate them or take other action. But they have to show that first. So in this case, the BART failed to accommodate these employees, and the jury found that that was against Title VII because they could have done it without undue hardship. And that's essentially, that was the sole question in this case.
And there were some really interesting aspects of this case. How often, Jessica, has a medical freedom law case gone to a jury?
As far as I know, I don't think any have gone to a jury.
Why is that?
I'm not sure, but I think it seems that there's a lot of delays that are happening. Like, for example, what's happening in New York. That case, as far as I understand, all of the cases have been stayed for many, many months, pending, I guess, some kind of federal determination on certain of these issues. And to me, it seems like a delay tactic, but I don't know why it has taken so long for everybody to get to trial on these issues.
Do you think judges and others were scared of cases like this going to a jury?
I mean, maybe. I don't know. I can't answer that. It's possible.
Okay. Let's move to the plaintiffs then, and then we can explain more about this case after we hear their stories, because I think that the stories really bring it to light. And then, Jessica, I'd really like you to explain some more of the details of this case so people really understand what happened legally here, and,
Okay.
and why this is such a big deal, that this is a win. And, you're the litigator extraordinaire.
Thank you. Okay, sure. I'll stand by.
So Clint, I'll turn it over to you, and I don't know which plaintiffs you want to bring on first, but go ahead.
Yeah, well, I want to let people know that I was intimately involved in one of the plaintiffs' case from the get-go. So as Alex mentioned earlier, in the period of the lockdowns, it created a company called Commoner Law Group, which is designed to help ordinary people be empowered with a law sufficiently to protect their rights and other matters in their lives. Because if you remember, in the COVID era, the lawyers were not showing up, and the unions were certainly no help to these employees. All the institutions and all the people that employees would normally turn to when their rights are being infringed just weren't there for them. And so we produced a course called Sue Your Employer for Firing You Because You Refused the Vax, which gave ordinary people a thorough education and gave them the empowerment to write their own lawsuit. And so one of the plaintiffs who isn't with us tonight is Bradford. He's a hero, and he's one of the six. He wrote his own lawsuit and filed it so many years ago, and it withstood any procedural attempts by BART to stop his trial moving forward. It just so happened, though, that simultaneously, dozens of other BART employees finally did get together with an organization called the Pacific Justice Institute to represent them as a group of plaintiffs. And a judge in this case, a federal judge, recognizing the similarities of Bradford's case, lumped his case together with all the others. And Bradford agreed to work with the Pacific Justice Institute. And those are the lawyers that carried the case forward for the bulk of the time that the case was moving through the courts. And I was helping Bradford along the way, consult with him, because he is, even working with lawyers, you have to be really on your toes in terms of what you want for your personal outcomes, and everyone's a little different. So there's a lot of strategizing, a lot of brinksmanship, a lot of just thinking, chess maneuvers. And so I've followed this case since the beginning. And then when the last trial happened, I got the wonderful, wonderful gift of meeting all the final six plaintiffs, the last ones standing. And what it tells me, what I gained from it all is life-changing. I'm a new man for having met these people. It's no accident that it was these six people who ended up victorious. There was so much pressure along the way, and we're going to hear from these two plaintiffs the kinds of pressure they experienced to settle out of court, which would have meant non-disclosure agreements being signed, which meant that we wouldn't know as the public how much they won, and what the victory was wouldn't be public the way it is now. And I'll just give it away. Those six folks, very much filled with faith, true faith. When we say religious discrimination, we're not just talking about some sort of legal hack that they use to try to get away with something. They are the real deal. And they committed to each other that they were going to go all the way to the end, regardless of what it meant for their financial outcome, that there was something more important than money to them. And I want to highly emphasize that that's what carried the day. The judge, the jury, the attorneys on the other side, and even the plaintiff's own attorneys were highly motivated to settle all along the way. And the amounts of money that the BART was offering to settle, it's true, from the beginning were small, but they kept going up and up and up until a critical moment in this most recent trial, when it was clear that the plaintiffs were very likely to win, and then BART was offering a lot more money and a lot more pressure to settle. But again, because of their pure commitment to having a jury verdict that then the rest of the world could point to for plaintiffs in similar situations around the country, to help them out. So I want you guys to think of these folks as something else, something a cut above. You're going to have your own word for how awesome and wonderful they are after hearing their stories. But I just want you to listen from the point of view that this isn't just any ordinary set of plaintiffs. So we have one plaintiff we'll start with, who's simply known as Plaintiff. Because some of these folks, they aren't interested in they want the jury verdict to be very much public and the victory to be public, but they themselves individually aren't necessarily interested in the spotlight. So thank you, Plaintiff One, for
Thank
being
you.
here.
Thank you very much.
Yes, again, I'm so grateful to meet you and the others. You guys really moved me in such a profound way to see the way you operated and to spend time with you during the breaks and during the period when the jury was deliberating and talking about our spirituality and talking about a higher order of things. It really, really was a wonderful experience. But how about we start right back in the beginning, and just kind of move forward chronologically. And we're just interested mostly in your personal experience of what it was like. So you got alerted at some point, probably a memo, an email that said, "Hey, there's this vaccine, and if you want to keep your job, you have to take it." What was that like?
The first time I received this message is from an email. And when I saw it, I say, hey, is this violate my contract? At that moment, I didn't realize the contract, they really mean the union contract. My background was I never worked for a government agency or something like that. I always work for a private company. Okay. So the contract to me is the agreement I sign up when I'm sign up for the work. So I say, hey, I didn't sign up for the vaccine. How can you mandate? You change the agreement between us. So that's my first reaction. Say, hey, that's a contract issue.
Mm-hmm.
I didn't think about any other thing yet.
And how did that go when you disputed it as a contract matter?
Oh, after I make a phone call right after the work to the human resources to say, hey, I didn't sign up for the vaccine. How can you mandate it? They say, oh, this is not changing the contract. Again, at that time, I didn't realize the contract, they mean union contract. Okay. I never work for a union at all. So they say it's just change of work condition. And then they blah, 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 say a few things and say, if you're not follow the mandate, you will be terminated. That's a shock to me, actually. So how can you say, hey, do something without prior agreement and then you say terminate? I understand that's their right, because for a private company, to me, is you can the employer can terminate an employee anytime without reason, and the employee can resign the work from the employer anytime without reason. So that's fair. I think that's fair. So I said, okay, fine. But then after that, I wrote a letter to them, say, hey, I saw the human HR means human resource and human right. So that's it. So I think they violate the human right. That's the first reaction I have.
Correct. Yes. And specifically, one of the most important things about being human, which is your connection with a higher power. You were one of the six who wasn't a Christian person as such. You have a religion I had never heard of before. Want to just say a little bit about it and how, for you, your religion, as if you were on stand, because you were given the same question when you were on the stand, right? How does your religion have anything to do with refusing a vaccine?
Okay, my religion is called rulism. Sometimes some people call it Confucianism. Okay. Anyway, this is a long history. It's over thousands of years. So the conceptual wise is similar to the Christian. Okay, we have something called Tao. That's the rule manager or ruling the whole thing in the world, universe, put this way. And similar to the God of a Christian. So when the translation, usually we use God. So, but actually they are a little bit different. So my religion says my skin, my hair, everything is inherited from my parent. So I cannot harm it at all. Then after I put out this word, probably a year after, and then I found out there's a similar scripture in the Bible. It's called "Body is our temple." Then I realized that we are talking the same thing, talking about the same thing. Okay, so basically, that's my religious is body is our temple. We have to respect it, and also ask a question. After I realized there is a scripture in the Bible, I say, hey, how Christians deal with it? Should we protect? It's our responsibility to protect our temple? My answer was yes. Oh, so same as us. That's also our responsibility to protect our temple. You cannot to to invade my body. Let's destroy my temple. That's the whole thing. But
Very good. Thank you
so
for making that claim because, back when folks are filing their initial complaints, we we stood on those grounds, but we didn't know if it would hold up in court, and I guess it did. So, what was it about your experience that had you want to even begin a legal process? A lot of your coworkers, they retired early, they quit and got jobs someplace else. Some of them, I believe, I'm guessing, got fake vaccines. There were a lot of ways that BART employees tried to solve this problem other than straight on suing BART. So, what was that like, your decision making?
uh, basically, my thinking was my case, or I put this way, my problem is also other people's problem. So the first thing is I say, if nobody stand out and speak, then everybody will be forcing to do whatever the upper guy wants you to do. Then I say, okay, I, I, I just want to go through this whole thing and make a precedent so other people can follow. So in the future, not only BAR, but also other companies will not do this kind of thing to their employees because that's not fair. Because you judge me or judge any people being fired, not by what they can or cannot do, but by what they are or they are not. That's unfair. So my job is you hire the company hire me or the organization hire me because what I can do is not what I am or what I am not. Right now, if I'm not vaccinated, then I'm being fired. That's unfair. That's all whole thing to me.
So, yeah, you were committed to justice in your own personal case and justice for everyone. That's emblematic of all six of you plaintiffs who won. And I thank you again for being that kind of guy. So you found yourself in a lawsuit with a bunch of other BART employees. And maybe you could just characterize, broadly speaking, what's it like? Most people haven't been a plaintiff in a lawsuit ever, let alone a plaintiff in such a high profile case.
Uh, to me, I never been a court or never been in a lawsuit. I don't understand law at all. Okay, I shouldn't say that a little bit. Just a common people law is just the thing you understand. So this thing is a complete stranger to me. I basically start all the case by case reading and trying to figure out. Even we have an attorney, PGI helping us, and I still want to understand the law, why and how to to uh, to make our voice out. That's the whole thing, because there are so I would say, excuse me, you're going to edit this anyway, so cut it if it's not probably. Okay.
You're doing great. Go ahead.
Okay. The whole thing is, short after I studied the law and I found out this lawsuit or the whole legal system is a rich man game. It's not for poor people, not for common people. How many people can afford to go to everything, go to Supreme Court? And I estimated what would be my loss. Well, as I told all our partner, our plaintiffs, say, hey, the worst case, I'm expecting I'm going to bankrupt. So yes, I'll go bankrupt until I fight to last penny. That's all I said to other people. I say each person has a different situation, so make your own judgment. Don't follow me, but I am going to do that.
Beautiful. Again, I'm so moved. Thank you. So there's a couple of important distinctions in the law that you learned, I'm sure, about employment law you didn't know going in, and maybe Jessica can help out if you care to. But for the legal warriors here, we want to make sure that you at least understand a couple of fundamental elements in proving a case of religious discrimination in employment. And one of them is, of course, the religious exception itself, like the declaration that the policy of the company does not comport with my religion. And then the second thing that most people may not know, that the employer has the opportunity to decline to accommodate that religious belief if the company can prove that doing so would cause them an undue hardship. That's the way it is in the law. Jessica, do you want to just maybe elaborate on those two elements and what you were thinking about in terms of strategizing and how you focused, you honed in precisely on those two elements and how the court maybe treated them and how you were ultimately successful?
Yeah, so I mean, the law is very clear. And when someone, and this is the thing that I think a lot of people had a lot of questions about, that in the trial was not a huge deal, which is, how do you show the sincerity of your faith, or how do you make that declaration and make it be accepted? And what you'll find in the law is that under the EEOC, for example, you're not supposed to scrutinize that. And it even says in their guidance, like, typically you don't scrutinize this. And the only time that they do, or that they say they should, is if they have a question about whether it's a sincere belief or not. There's an objective reason why, they might think there's something wrong with your claim. And one of the things they look at, for example, would be the timing, right? Like, you become born again, like the day they say, announce the mandate or something like that. Or if you have other beliefs that they believe are masking, the real belief. And so, but this is very uncommon, as I think you said earlier. Before COVID, this was never an issue. If you expressed a sincere belief under Title VII, the employer would take it very seriously, and then, usually you wouldn't end up in court. It would be pretty rare that they would just not accommodate. But what we saw during COVID was kind of a mass wave of failure to accommodate these kinds of requests. And I think that was largely driven by a lot of maybe the media. And there was this narrative coming from some insurance companies that if you didn't do this, then you'd get sued. And, I don't know where that came from, but what we see now, and historically, Title VII claims have been taken very seriously. The law is very strong, and it's, employers need to accommodate people with their beliefs. And here, unfortunately, it seemed that a lot of employers made a decision that they're just not going to. And there's also this question that I think is actually still pending, kind of nationwide, which is, can your religious beliefs trump, quote unquote, public safety? And that's a larger discussion, but those are the kind of things that I think were at play when they were scrutinizing these requests. And and in this case, we had some of the plaintiffs' requests were granted, but then at the end of the day, they were not accommodated because BART claimed that they had undue hardship to accommodate. And the crux of these cases in the COVID era seems to be, this question of, can the workplace be safe with unvaccinated people there? That sort of seems to be the question that's running around. And to me, it seems a little bit strange because, there's been people who had flu and various other illnesses in the workplace for a long time, and it never rose to this level of frenzy of like, you can't be around anybody who's, and so I don't know how it's going to end up, but this jury verdict seems to show that, when it comes to juries, they don't seem to accept that narrative. So
yeah, in this case in particular, it was a big deal when the judge determined from his position of authority, apparently, in the case, to determine that an undue hardship, where previously maybe was considered simply a financial matter, that is, to accommodate a religious employee would basically bankrupt the company or somehow unduly burden them based on just the financials as a company. But here he said the undue burden test could also include this somehow some obligation by BART to protect the community from COVID. That was a big deal in this court case, wasn't it?
Well, that's the interesting thing, because like I was just saying, this is all new. So the law is evolving. And so what the judge was pointing to was other cases in the federal court, I believe here in California, that talked about this, because some other cases had come down the pipeline. And previous to COVID, you never had a question of, is the undue hardship a matter of public safety? That sort of never was addressed in any case, because that, you can imagine that any religious request, which typically had to do with taking days off, wearing certain garments at work, whatever, there's a lot of different things like that. Never something like this. So the law has been evolving, and that question is still kind of up in the air. And it actually was interesting at the trial, because there was a jury instruction that was hotly debated in both trials. And I argued against it in the second trial, because to me, it seemed like it didn't properly say the state of the law. But again, this isn't totally decided. This is very new law. So the judge had the opinion that no, and the jury instruction essentially said, and I'm paraphrasing here, that, an increase in the risk to the health and safety of the other employees is an undue hardship. That was what he told the jury. So in my mind, that sounded like, wow, this is like a really high burden to, there's any increase at all of any kind, like that doesn't seem like the same standard as it's going to bankrupt the company, in the financial world. So it didn't seem congruent to me. I argued against it, and in court, he said, I look up to the Court of Appeal to right my wrongs if I'm wrong about this. So I was worried about that jury instruction personally. But even with that jury instruction, the jury found in favor of these plaintiffs. So on that point, I think that will be a big question going forward in a lot of these trials, is what is the law on that point? What is undue hardship when it comes to this kind of a accommodation, which is very new and novel?
If I can interject, it's a really interesting question, and it is a novel question. Jessica, how does the decision in the Supreme Court in January 2022 play into this? Because that was the EEOC case where they had the illegal EEOC mandates, and the Supreme Court came down in January 2022 and said that because vaccination is not something that can be undone at the end of the workday, it's not an appropriate workplace mandate. So how does that play in here?
It was my understanding, I haven't looked at that case recently, but it's my understanding that it was a matter of federal power, and the EEOC didn't have the right to regulate this across the states, because that wasn't they didn't have the power to do that. Mm-hmm. And I think that's why they rolled back their own, mandate at a certain point.
Mm-hmm.
Yeah.
2021 was definitely an interesting year scientifically because, if there were two people in a room, depending on who you asked, how many people of those two need to be vaccinated to prevent the spread of COVID in 2021, people would have answered two. Now the answer is zero because they never did prevent the spread of COVID. It's the landscape, the scientific landscape, or actually like the lay understanding of science has totally changed finally and caught up to the reality that they never stopped transmission.
Yeah, it's interesting because that came up at trial. They had a couple of experts that testified, and one of them was a industrial hygienist, and I cross-examined her, and she had the opinion that basically any unvaccinated people in the workplace were a high danger. And so then when I was questioning her, because she again, this is another person that before COVID never did this kind of thing. The thing she dealt with was like chemical exposure or like spills or whatever at work, which is a totally different thing, obviously, right? She's talking about ventilation and what kind of air is coming through, and that's a whole different animal. And so when I questioned her about, well, I asked her, isn't it true that if something has a 1% chance of killing you versus a 50% chance of killing you, then the measures are totally different. That's a different level of danger. And she her head exploded and she didn't want to answer the question. And so, and I think she really actually hurt them because she was all over the map. And she also talked about herd immunity. And in her report that she had done, which they paid her 30 grand for, by the way, she opined, she talked about herd immunity was between, 70 and 90%, I think is what she said. And, but then when it came to her opinions about what, whether there was herd immunity at BART or whether that could be a factor, she was just like, no, she tried to just backtrack completely and say, and then when I asked her, do you even know like the case fatality rate of COVID? And she's like, I have no idea. And that was.
And that's how Jessica plays it. She's an incredible litigator like that.
Yeah,
exactly,
but we did get into the
gotcha moments when Jessica is doing her job.
Yeah, because what we're witnessing is an unreasonable attempt by BART and other employers across this country, the government as well as private sector employers, just bending over backwards to do anything to make sure that they have total compliance with their employees. And it's based on a stack of lies and misconceptions. And so it takes a talented litigator like Jessica to go in and exploit the contradictions and the obvious illogic of so many of their positions. And isn't that good news? That when you do scrutinize their logic, it falls apart. So thanks for your good work. Let's mix it up just a little bit. We'll come back to you for sure because we want to hear more about accommodations and how the trial went. The way the trial unfolded was just so interesting, better than any Netflix series you might have watched. But we have another plaintiff here, Ryan. If you're with us here, I would love to hear your voice. Of course, you too were one day showed up to work and you were told, I either have to take this experimental injection or lose my job. And so just what was that initial experience like?
When COVID hit, I usually travel to Colombia, Venezuela. That's an area where people don't get vaccinated. The reason I bring that up is because when I came back, I was aware of COVID spreading in 2019 when they used to call it Corona. And I started studying it with my ex-wife at the time that viruses could never be cured. I don't believe there's any virus that's been ever cured or eradicated. They say smallpox, but it pops up. I don't know if you remember Ebola or Zika. I used to be a limo driver for the Warriors, and Zika caused Steph Curry not to go to Brazil due to the mosquito biting and the baby being premature. So there was actions in the past where you would not go to these countries, which I have. So being familiar, I knew there was never going to be a cure for COVID. there's never going to be uh, a virus that they can stop. So basically, pharmaceutical companies are going to basically, it's like a casino to them. It's just going to rack in the dollars. No disrespect to them, but that's just what's going to happen. So when I was going through my battles with the union in September of 2022, they put out a memo from a law firm and they started to build a framework. And the framework was basically going through what you see now is we're all fighting shadows. We went to every attorney you can find. They said they're not going to put their neck out there. The law is new. You're just fighting shadows. You're never going to win. Um, it's a battle you can't fight. So I decided to take my stance. I went through the process. I knew it was a sham. I was told at union meetings, you will never, ever get accommodated, not even for medical. And I knew I was going to walk out the door. I prepared months before my termination, and I was going through all the religious sham process that they put through. And at the same time, I don't know if you remember in 2020, there was the sky turned red, which brought me closer to God on September 23rd, 2017, the Revelation 12 sign, which brought me more to my religious end and knew this would be basically a battle of David versus Goliath, um, which is kind of funny because one of the persons that terminated all of us, Stone, was in his last name. And I believe that the stone that was cast back at BART took him down. I was in the first trial. Jessica wasn't a part of the first trial. We could have won that trial. Um, we were heavily pushed back by our everyone, the judge. The jury wasn't told a lot of the truth. Basically, this
Yeah,
was a
let me
sham to get rid of everyone that's religious. But go ahead.
No, surely, surely. Yeah, when we look at when we look at the totality of this story, it's clear that there was religious persecution is not too big of a word to say.
Mhm.
Um, there are people who just really don't accept that other people have a higher power and that they have sincerely held religious beliefs. There is a war, if you will, against belief and believers today, and that became clear in your well in your story, but so many stories across the country. But I do want to point out something, emphasize for the folks here who are really interested in learning the law, that some of the more deeper distinctions in the law. I don't know how new it is actually, but it was new to me that it's become customary that after a trial, after the jury has delivered its verdict, that there's an invitation for the jurors to be interviewed by the parties, the lawyers and the parties, to find out how did you come up with your decision. And after the second trial, the one that you just completed victoriously, the jury, as well as this determining the multi-million-dollar award to give you guys, they also agreed that they were not going to accept any questions, that the entire jury agreed at once that they weren't going to allow for an interview. But at the first trial, which was just a couple months ago, right? A couple, 3 months ago, the jury did
July. Yeah.
allow for it. And that became a big learning lesson for maybe that helped in the success of the second trial.
The second trial was worse. It was 10 times harder, and that's why more people settled because we were going into trial, the second trial with at least 17. Out of the 17, you ended up with six because of the
Yes.
stress. Yes.
A lot of people got stressed out. They're just like, I don't care. I'm just over it.
There was an extra stress. I'm not sure we talked about this Rule 68, where if you'd actually lost during the jury trial, you would have had to have paid all the attorney fees, right? I mean, this was
Uh,
high
n-
stakes to go all the way.
it was worse than that.
Yeah.
You were basically told you would lose your home, garnish your wages. You would be responsible for all court fees, not BART's fees or attorney fees, because they had a outside counsel, but you would be responsible for everything, even their expert witnesses. They bring a total amount close to 400K. If we would have lost the second trial, probably would have been close to 1 million, which we would be responsible for, split six ways. And BART would have came after us within the first 30 days to file for payment. So, I mean, I've had my mediation. I don't know if I could go into it, but basically, I said I came here with nothing. I'll walk out with nothing. Um, so that's where I didn't care what I lost. All I had was my faith. I got divorced. My pet died. I lost a home purchase. I lost everything. There was nothing left other than my faith. So if this has happened before in the Bible, if you look at Nebuchadnezzar, There was three, Shadrach, Meshach, and Abednego, that they were told if they didn't bow before the golden statue, they would be thrown in the fiery furnace, and they lived. And they didn't, you couldn't even smell fire. So it's a story I build on. Most of my faith is built on these stories, even splitting the baby, how they did the accommodation process and the religious exemption. They split the baby. A baby can't survive if you cut it in half. King Solomon did that when two women were fighting over who was the true parent, and they did that with my religious exemption. You cannot split the baby in a religious exemption and say, well, we could give you a religious exemption, but we can't accommodate you. That's what they did. And every legal aspect, I introduced law to them in my termination, which was uh, the EEOC, also the Supreme Court, and also the President of the United States at the time was Biden, who introduced the Federal Transportation Act, where you couldn't discipline anymore, and BART did not care. So we call that the BART way. BART basically does whatever they want when we call it the BART way. Yeah.
So basically, Ryan, you could have you had a bird in hand, which is why what like 20 people ended up settling, because you could have had a bird in hand with a pretty high settlement amount. Or if this had gone like the totally wrong way for the six who made it through, you wouldn't have been awarded $1 million+. You would have had your pay garnished for $1 million divided by six people, right?
Right, but
That's
like I said, I was very confident my faith would have taken me to victory, which is, when you mess with God, he will destroy you. And he basically took down everyone that stood in front of him. And I hope they all get on their knees tonight and pray, because he basically put his will into the jury. And that's why they didn't speak, because he did that with Jesus's father. He wasn't allowed to speak until he said his name when he was born. So if you know your religion and if you understand it, most of the law you study is Latin and based on the Bible. The Ten Commandments was what the Hebrews asked God to give, what's law and order. And then, all of their laws and order were put into the King James Bible, which I bring up in court and testify to. This is a case of faith for me.
clearly, wow. I mean, it's just such a stunning story of faith. I mean, I'm blown away that you were so confident in your faith that even with those odds stacked against you, your faith carried you through to this incredible outcome. Well,
Yeah, so
bravo.
let's all celebrate.
Yeah,
Let's
exactly. I'll turn it back.
let us celebrate and be
Yeah.
thankful for something bigger than all of us. That really, I believe, I can't believe that this happened. The first trial, only one person, it was only one person held out. You would have lost the case, but one person kept it alive, which made it possible for the second trial. And then all eight jurors unanimously uh, awarded you a victory. So something happened. Again, it's just beyond belief. And I do believe not only is God good,
Oh.
but you six had to be worthy of it. And everything I'm hearing tonight and everything I know about you guys is you proved you're worthy of that victory. And that's how it was able to happen.
And then I'd like to add to that one juror, the judge made him speak because the jury was upset with him. They said he won't pay attention to us, he won't rule with us. And God was involved, because when he spoke, he even made a judge who was very powerful silent. He basically told them, in my heart, I know that Bart could have accommodated them. And he really, really uh, silenced the courtroom. You can hear a pin drop. And it was pretty amazing that he basically said that and some other things, to where the judges said, okay, it's a hung jury and we'll go to retrial.
Let's check in with Jessica. Is there anything else these legal warriors need to learn about this case that we didn't already talk about? Is there something about this case, maybe uh, about the case itself, or what still is to come? Because so often in legal matters, things aren't always done when you think they're done.
Um, it's never over till it's over. And you know, BART could appeal this case. I don't think they should. I don't know if they will, but hopefully we'll see the end of this, and you know, secure this victory for these plaintiffs, which, like you said, are an amazing group of people. I spent a lot of time with them myself, and they're all awesome and very cool, and really, really, really amazing people. So,
Okay, let's take a question from Wednesday.
Hi, guys. Ryan, first off, I have to commend you. You are amazing, and I cannot wait to read your book. So please write one. Jessica, I was curious if the ruling that the Supreme Court did about OSHA and the fact that not every workplace was a hospital because they're a the only use of OSHA could have been because it was saying that the hospitals were a danger because everyone was coming to them that had COVID. So all of the people would come to the hospital, and that would be danger because everyone was coming. But every other workplace was not a hospital. Therefore, it wasn't a danger because the people weren't flocking to those jobs because they had COVID. So it's like, did that have any play in it at all, or no?
no, it didn't. OSHA did come up, but that's not the standard. Regardless of whatever OSHA was saying, the standard is undue hardship. So that's what had to be focused on in the trial. And you know, OSHA regs kind of went in our favor because there was regulations that said that if for unvaccinated workers, you can have them mask and test. And we brought that up, but that wasn't what the standard was in that, and BART wasn't following OSHA necessarily, and they weren't required to.
And if I could do a follow-up, so does this set a precedent now for other people to be able to look to your case and say, how that sets precedent? Is that now a strong case?
It's not precedent setting in terms of, when you say precedent, usually it's like somebody else can use it in a different court case to force somebody to do something. But it is precedent setting in terms of what a jury may award for these types of cases. Because like I said, we haven't seen that.
Right.
And so that's something in the legal world, there are, huge volumes of data that are kept about jury awards and what happens there. And excuse me. So here, this is going into the books, and that's what insurance companies and people like that use to determine what's a proper settlement and stuff like that. So it definitely is setting a precedent there, because once you have this kind of verdict, because it's all about managing risk when it comes to, lawsuits traditionally, except for when you have people like Ryan and these plaintiffs that it's about going with God. But usually it's about managing risk. And so when you have this kind of verdict that's on the books, that certainly changes things when from the other side looking at the risk of going to trial.
Right. Where are these books located so I could tell my friends that have cases?
There are services that you have to
okay.
Subscribe to. They're pretty expensive too. But you can get them through like Westlaw or like LexisNexis. They have jury award
awesome
things, and anybody can look it up, but it is expensive.
That's fine. Thank you. And congratulations.
Thank you.
Yeah, this victory is for everyone in the sense that if you're a plaintiff in a case like this, it's your burden to convince that jury to award you what you're asking. And so now other plaintiffs around the country are encouraged, and they're less likely to cave to the kinds of pressures that they're experiencing in terms of the risk reward analysis that both their own attorneys and the judge and the other attorneys are trying to foist upon them. So they have a little bit more confidence that, hey, especially if a jury in San Francisco, given the politics there, maybe that's a good point to make for everyone. What did you learn, Jess, about the attitudes of the jury going into the trial about people who are unvaccinated?
Oh, yeah, that was an interesting part of it. because the jury, of course, in San Francisco, was at the end of the day was they were all vaccinated, and a lot of them expressed a problem with people who chose not to be vaccinated, because I asked them that question, and they were all very candid. And it was interesting because it's not that they were hateful or anything like that. They were just of another mindset. So they were like, and the woman who ended up being the foreperson said, I just don't understand why you wouldn't do it. And she said, but I'll be fair, but I don't get it. And so it's not like probably most people in this group that's like, obviously there's a million reasons why you wouldn't want to do it. But for some people, that's not something that's in their world. Like for them, it's like, what do you mean? That's why in the world wouldn't you? Like, this is the first time I've heard this. And a lot of people in San Francisco are kind of like that. So, that's another thing that you have to speak to the jury that you're talking to. You can't ignore the audience when you're, presenting this information, because they have a certain view on life, and you have to take that into account.
That's right.
I saw somebody else had a question, but I don't know where that person went. Did that?
Yeah, if you have a question, go ahead and raise your hand and we'll get you questions. In the meantime, plaintiff one or Ryan, if there's any.
I wanted to add, I took a lot of notes. BART did not care about your health and well-being. They allowed people to smoke. I had people on the train defecating, urinating, having sex during COVID. I was hazmat, the only one in BART that had hazmat. I was trained under the U.S. Department of Transportation, and basically it's on the back of my license. BART did not care. I could wear a hazmat suit. They did not care. They did no financial outlook. They did no interactive process for accommodations. That was all not really brought out too much in court, but you should know that if you're, I guess, putting in your notes that there was actually nothing done financially, nothing done to really interactive accommodation process. Nothing was done. So if you do refer to the case, you probably want to put that in your notes that these things weren't done and BART lost. And they had people with actual hazmat, me, that's trained to clean up spills. I work with hazmat materials where you can die, or there could be an explosion. That's why I have it under my license and I'm qualified for it. So I just wanted to throw that out there if you wanted to put that in your notes.
Thank you. Yes, their behavior betrayed their true beliefs about health and safety. Go ahead, plaintiff.
Yeah, one question is regarding to the law. Jessica, you mentioned once, but I didn't catch at that time. You said regarding to the reinstatement, there are two kind of court or judge, and I didn't catch it that time. One time you said one time you can ask for reinstatement, and then the other one you cannot. So can you explain a little bit more, or did I catch wrong?
Are you talking about when we spoke before?
Yes.
Yeah. Okay. Yeah. So in this case, there are different avenues that you can try to take. You can sue for what's called specific performance or an equitable type of relief where you want your job back. So that would be called reinstatement. So you're suing for like reinstatement, or you can sue for wages and damages. So those are mutually exclusive, right? You can't get both. So when you go down the path like you guys did, where you are getting the wages and damages, then that's the path that doesn't include reinstatement as something that you can get out of the trial.
So you said that two are exclusive. So if I claim some damage, I cannot claim reinstatement.
Right.
But actually, in reality, the damage is caused by losing the job and losing the pay. So that's the back pay. And the reinstatement means if you did something to me, reinstatement means if somebody, the employer, did something wrong, they need to reinstall the whole thing back to the original. That's
Right.
to me. So I don't know how law to regulate it or explain it or whatever. Your time.
Well, rolling it back to like what it used to be is what's called an equitable remedy. So you want somebody to do something to like fix it. Um, but another type of remedy is damages, and you usually can't get both in this kind of case. Sometimes you can claim both and then settle and say, I'll take this much for my wages, and then I also want to get my job back, for example. But when you go forward to a jury trial and you are awarded damages, that's what the result is. It doesn't include the other remedy at that point.
Got it. Okay. Thank you.
Yeah.
Does Wednesday have another question, or is your hand still raised from before?
I'm curious how much the not giving an interactive process, because my union also gave no one interactive processes. Literally people got fired off shows that, it was just a cluster. It was a mess. How much did the not following the interactive process or giving one, even though it's in the contract, did that help with the outcome of the trial?
That was not, interestingly, that was not actually discussed that much. I mean, the jury found that they failed to accommodate, and we did the trial kind of backwards, so we didn't discuss the kind of exemption process until after they found that that they failed to accommodate. So I don't know, it was kind of an interesting twist to it, but that didn't, I mean, there was a little talk about that, and that sort of was part of the theme of the trial. Matt McReynolds, who did the opening argument, he did say that this is a sham process and they didn't really engage, and that did come out at trial, but it didn't seem to be a huge factor in terms of the decision, in my view.
Okay. Well, thank you, everybody. I think this was a great call. I learned a lot, and it was really great to hear from the plaintiffs in this case. Really compelling stories of faith that just are so inspirational to me, and I'm sure everybody on this call. And I hope a lot of people will watch this and also be equally inspired by these stories of faith, because that's what won this case at the end of the day. It was really nothing else but that. And so thank you so much, Ryan, and plaintiff number one. Thank you, Jessica Barsotti, litigator extraordinaire. Thank you, Clint Grease, for being the consultant, helping these plaintiffs on this case. Thank you, everybody, so much. And be sure to share this video with your friends and family. And it was incredibly informative. So thanks, everybody.